If you're a firearm owner in America, the earth just shifted under your boots and most citizens still haven't felt the tremor. A December court decision landed so large it's shredding restrictions that stood for generations. We aren't talking about minor edits to old statutes. We're looking at 10 core shifts that redraw what you may or may not do with your guns. Law number 10 is flat out wild. What's suddenly lawful will leave you staring at the wall. Smash subscribe this second, because knowing these updates isn't optional any longer. It's the line between exercising freedom safely and catching charges you never saw arriving. Law 1. The strict scrutiny standard. Law number 1 is the bedrock that lets everything else breathe. It flips the judicial lens on gun statutes from this moment forward. The Supreme Court just parked your Second Amendment rights at the highest tier of constitutional shelter, meaning any rule that tries to shrink your ability to own or carry now faces the toughest exam in American law. That exam is called strict scrutiny. Here's what it means in simple terms. Before this ruling, if the state wanted to crimp your gun rights, you had to prove the rule was broken. Now the script is flipped. The state must prove to the court it has a crushingly vital motive for limiting your freedom, and it must show it's trimming the absolute least flesh possible. Law 2. Police lose immunity shield. Law number 2 rewires how officers treat gun owners, planting real penalties when rights are trampled. For decades, cops could snatch your sidearm, cuff you for lawful carry, or treat you like a felon simply for exercising Second Amendment freedoms, then duck behind qualified immunity when you sued. That shield is fully gone. If an officer violates your gun rights, they can be held personally liable, meaning they can lose their own cash, face federal indictment, and even kiss their badge goodbye forever. The court was crystal. If any reasonable person would know stealing a legal gun or jailing a lawful carrier is wrong and unconstitutional, cops are expected to know it too. Law 3. No gun seizure without charges. Law number 3 slams the door on the state grabbing your guns without running through full criminal procedure first. The court struck red flag schemes that let bureaucrats seize firearms without charging you with any offense. Civil forfeiture for guns is dead. Cops cannot pocket your pieces during an investigation unless you've been formally arrested and charged with an actual crime. The court's line is blunt. No seizure without arrest, no seizure without charges, no seizure without due process. That ends every "we'll hang on to these while we poke around," or "someone said you're risky, so we're holding them for now" scenario. Those days are buried. Law 4. Feds must wipe gun owner databases. Law number 4 is a monster privacy trophy, ordering Washington to delete records it's been hoarding on you. The ruling commands every digitized gun owner file the feds have cached to be erased completely, and they have just 90 days to prove it's done. The decision states plainly that searchable registries of gun owners breach federal law, no exceptions. States that have been feeding owner data to DC must cut the pipe instantly. That sharing is now deemed joining an illegal registry. ATF has exactly 90 days to deliver proof of destruction. Law 5. Permits issued in 30 days flat. Law number 5 chops the red tape around carry permits, forcing states to issue them fast and fair. 3 non-negotiables now apply coast to coast. First, every permit must be fully processed and handed over within 30 calendar days, no extensions, no year-long limbo. Second, states cannot demand a special reason or good cause statement. The Constitution is your reason. Third, the fee is capped at $50, so blue states can't price regular people out of the queue. If your paperwork has been gathering dust, this ruling kicks the door open. Law 6. Digital spying on owners outlawed. Law number 6 locks your online life against snooping, ending creepy backstage habits that bloomed for years. Agencies were quietly mapping citizens simply for buying guns, logging ammo clicks, tracking store visits, scraping social posts, and hoarding search histories. All of that dies today. The court announced that exercising a constitutional right cannot justify round-the-clock surveillance. Your location pings, card trails, and browser data tied to lawful gun activity are now walled off from warrantless phishing. If pressed, answer short, digital surveillance of lawful owners is banned under this ruling. I do not consent to any search of devices or records. Law 7. Gun businesses get full shelter. Law number 7 7 is a landmark win for anyone holding an FFL or planning to. For years, ATF used foggy regs and surprise inspections to torment dealers. That era is over. The decision treats gun enterprises like any other lawful trade. Paperwork typos can no longer kill a license. Revocation requires an actual crime. New FFL applications must be processed within 60 days, not half a year. Bottom line, run a clean shop and you can finally breathe without staring at arbitrary shutdowns. Law 8. Ammo sales return to normal. Law number 8 fixes the headache every shooter knows buying cartridges. States had stacked odd rules that turned a 5-minute purchase into a maze. The court recognized the obvious. A firearm without ammo is a paperweight, and treating rounds like plutonium never made sense. California can no longer force a background check on every box. New York cannot ban online ammo sales. Connecticut cannot cap quantity limits. Illinois cannot demand serial numbers on bullets. From today on, ammo is just another legal product on the shelf. Law 9. Your castle is fully shielded. Law number 9 fortifies your domain like never before, ending surprise inspections at your doorstep. Federal agents cannot appear simply because you own guns. Those random compliance checks collectors, home dealers, and everyday owners endured are history, unless the agents carry a valid warrant and not just any warrant. The government must now show real evidence of criminal conduct before stepping onto your land to paw through your safe. Whether you run a basement range or just keep a family heirloom, your property earns the same respect as any other right. If they knock, reply, "Show me a warrant listing specific criminal allegations, or you cannot enter." Law 10. Interstate travel shield is guaranteed. Law number 10 is the jaw dropper, and it's about driving across state lines with your firearm. For years, owners white-knuckled it through hostile territory, terrified of being popped in a banned state even while obeying every rule. That fear is officially dead. A federal safe passage guarantee now wraps responsible owners from start to finish. Here's the skinny. If your gun is legal where you begin and legal where you finish, you are federally protected the entire route. Stop for gas, grab a burger, sleep in a hotel, all covered. And here's the kicker. If you hold a valid, concealed carry permit from any state, you may carry on your person for the whole drive, regardless of what the states in between dictate. Quick recap. We just rolled through all 10 game changers. Strict scrutiny now sits on the throne. Cops who trample your rights can pay out of their own pocket. Red flag seizures are dead. Washington must wipe every digitized gun owner file. Carry permits have a 30-day deadline and a $50 cap. Warrantless digital snooping on owners is banned. FFL get 60-day processing and can't lose their license over typos. Ammunition is sold like any other legal product. Your front door can't be opened without a real warrant. And a federal safe passage shield wraps you gun on hip from the moment you leave your driveway until you reach your destination. Make sure you subscribe to Weapons Law Advisor. And don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.